Good day, Crime Talk aficionados. We have a great show for you today. First, Delphi murder trial, day 17. The defense rests. The Daniel Perry trial. The DA's big lie is being exposed. Karen Reed's attorneys argue before the state's highest court. Shock. Sarah Boone wants a new trial. Scumbag DA Alvin Bragg has been held in contempt. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Before we get started for the show, as you can see, I am not in the Crime Talk studios. I am in a conference room in Mesa County, which is Grand Junction, Colorado. Still no Crime Talk 1, so we had to drive it. And there was a snowstorm this morning, so I left the house at 6:15 a.m., and I have a little time before my hearing. Now, before we get there, you know we have to talk about paying some bills. Go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you're going to be able to do a background subscription service on one person or as many as you desire, as long as they are here in the United States. And you can do that when you have the subscription. And remember, you can cancel at any time. You literally type in the person's name. They ask you a couple of questions. You get a report generated while you wait, and it can be emailed to you, and it's going to have all the information you want to know about somebody. Where do they live? What's their social media presence like? Do they have a criminal history? Do they have judgments, liens? Are they married? Are they divorced? Is there something maybe that new person coming into your life is not telling you? You need to go check them out. Go to crimetalksearch.com. You'll be happy you did. All right, let's go ahead and get started today with today's docket. First on the docket for November 6, 2024. First, day 17 of the Delphi murder trial. Guess what, ladies and gentlemen? The defense has arrested, and Richard Allen will not take the stand. So the court began today, and the defense team apparently showed up. There was a little bit of a period of conversation outside of the courtroom by the defense attorneys, and apparently then they came to some sort of agreement as to there being no objections to jury instructions. And it is also noted that, guess what? Like I said, Mr. Allen will not testify. Is that a good thing or a bad thing? I'm telling you, as a criminal defense attorney, I have won more trials when the defendant does not testify. The reason being, the jury is looking at all of the evidence. Has the prosecution proven that case beyond a reasonable doubt? But when the defendant testifies, it really then just comes down to, did we believe the guy? Was he shifty on the stand? Did he make eye contact with us? Did he have beady little eyes? I just don't trust him. Did you see the way he turned in the chair? Completely irrelevant. But when they can only focus on the evidence that has been presented in court, the defense has a much better chance. Now, obviously, the issue here is going to be the bullet found near Abby and Libby, as well as the alleged confessions. Now, the defense experts tried to refute the government's experts, saying that the round found at the crime scene matched the Sig Sauer P226 that was found in Richard Allen's home. Now, the defense didn't say it wasn't his. They challenged the methodology in which they did it, which is basically saying it's a match, all right? Then the next thing you have to deal with for the defense is they had to refute the alleged confessions. I think they actually did a pretty good job from what I was able to read about it. Lots of experts coming in saying, hey, this man was in a state of psychosis, and what he said was simply not true. And they backed that up by putting on Richard Allen's family members, saying none of these things that he supposedly said he did to his sister and his daughter by some sort of inappropriate touching never, ever took place. So therefore, it's not credible. He was just the babblings of a madman. So we'll have to wait and see. The prosecution was waiting on one witness and to call as a rebuttal witness, but basically the defense case is over. Prosecution has a brief case in rebuttal. We will go then to jury instructions and then closing arguments. We'll see if that gets done today or if it will be done tomorrow. Another big issue here was that the judge, Francis Seagull, kept out all of the alternative suspect information that the defense really wanted to get into, and they tried. Yes, they did, but it did not work. Next on the docket, the trial of Daniel Penny. Now, this man, a former Marine, has had his name smeared as a vigilante and a racist, but the truth is being revealed at the trial. Now, the Marine vet tried to do the right thing and protect others in an impossible situation and got arrested and charged with manslaughter for doing it. Now, back on May 1st of 2023, a mentally ill homeless man by the name of Jordan Neely charged onto the F train there in the subway and began ranting at his fellow passengers. Now, witnesses have said that Mr. Neely claimed he didn't care about going back to jail and ominously warned that someone is going to die today. That's when Mr. Penny put him in a hold to subdue him, which led to Mr. Neely's death after the police arrived. Now, the prosecution wants jurors to believe that Mr. Penny was overzealous, that he overreacted to Mr. Neely's threats. But most of all, the district attorneys wants to remind jurors that Penny is a white guy and Neely is black. Now, the district attorney did so when she repeatedly referred to Penny as the white man in court. Now, the intent of that is quite obvious, and it makes this case about race, not whether Mr. Penny was acting reasonable in the circumstances to protect not only himself, but others on the train. But maybe it's not working out so well for the prosecution, because one of their first witnesses, Yvette Rosario, who caught the video of the encounter as she trembled with fear, testified that Neely's menacing made her so nervous she thought she was going to pass out. She says, "I've been in situations on the train where this stuff was, but nothing like this." Now, Rosario thought that she was in real danger, as many others apparently thought that way as well. That's when Mr. Penny went into action. Now, Neely's story is, it's sad, and he has a history of mental illness, and he's even been hospitalized under a plea deal in an assault case, yet was allowed to sign himself out of an inpatient treatment. Now, is there really, a bad guy in this particular case? Well, could it be the inept and hands-off mental health system that let Mr. Neely be on the streets that day instead of the psychiatric bed? Is it a justice system that cares more about the race than keeping New Yorkers safe? Now, Ms. Rosario made another important point for the defense. Now, even though in her video, other passengers can be heard telling Penny to let go of Neely, she said she didn't hear the protests in the moment on that train. Good point for Mr. Penny. Now, obviously, we'll never find out if Mr. Neely was actually going to follow through on any of his threats that day. Well, because Mr. Penny made sure that didn't take place. But the city's refusal to do its job is the one that's responsible for Mr. Neely's death. Ladies and gentlemen, the police officers showed up and did not want to perform life-saving measures on Mr. Neely because he was homeless. He was dirty. They were worried that they were going to get hepatitis or AIDS or something to that effect. That's the officer's testimony, ladies and gentlemen, not mine. I say, let Mr. Penny go now. Next on the docket, Karen Reed's attorneys take their argument to the highest court in Massachusetts. Well, and it sounds like the justices were a little skeptical of that. Obviously, Karen Reed, a mistrial was declared in her case. We have another trial set after the first of the year in regards to her hit and run case where her boyfriend was the victim. Now, the issue surrounding this is that Karen Reed's attorneys wanted a mistrial declared, which they got, but they failed to ask if the jurors had reached a unanimous verdict on any of the charges. And then after the mistrial was granted, the defense said, hey, the jury was going to find her not guilty of 2 counts. Therefore, you can't proceed on these 2 counts again. And frankly, you should just dismiss the case as a matter of double jeopardy. Well, the trial court denied that. And then the parties for Karen Reed, the attorneys, appealed to the high court. At the court this morning, the judges questioned the attorneys over the merits of the inquiry that took place. Associate Justice Frank Gazzanio noted that such inquiries are usually reserved for extraneous information, such as racism in the jury room. And the chief judge, Kimberly Budd, wondered about the limits of allowing an inquiry, which she suggested could open the door for other defendants to argue a jury came to the same conclusion, and that's not really what happened. Other justices raised concerns about juries having to discuss their deliberations during an inquiry, while others questioned the merits of holding an inquiry when 3 notes from the jurors made it clear they were at an impasse. Justice Kaffler stated, the jury wrote, "You have an exhausted jury," in this very eloquent message, saying, "We've done our best. We haven't been able to reach a verdict." There is no inkling in that they have reached verdicts on charges or that this only relates to the second charge. Karen Reed's attorneys argued that the judge, the trial court, abruptly announced the mistrial in court without first asking each juror to confirm their conclusions about the count or to give the defense counsel a chance to weigh in. But another associate justice said, well, Reed had some pretty seasoned defense attorneys who must have sensed that a mistrial was possible when the judge gave juries what it called the Tui Rodriguez charge, a last-ditch effort to get them to reconsider their position before a mistrial was declared. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial, the judge noted. The attorneys for Reed pushed back a little bit on that contention and said that the defense didn't have an opportunity to be heard. How do we factor in that you've got to know what is going on the table, which is possible mistrial? What obligation is there to say, hey, before we declare a mistrial, let's talk about alternatives to that? Now, the prosecution has argued that no verdict was recorded by the jury, and there was no mention in jury notes to the judge. So Reed was not acquitted, and therefore retrying her doesn't violate her Fifth Amendment rights against double jeopardy. So obviously, we're going to have to wait for a decision from the Massachusetts High Court there, but I think the prosecution is right in this particular case, and I've mentioned this before. You had very experienced attorneys. They could have asked, whether it's the prosecution, the defense, or even the judge, saying, hey, let's ask them if they've reached a verdict on any of the counts. Now, the judge did say, let's do this, but that note was pretty clear from the jury that they're in a complete impasse. They didn't say, oh, we're stuck on one count, but we've reached decisions on the other 2. I think the court is going to rule against Ms. Reed in this particular case, and she will be retried on all 3 counts. But hey, we'll wait and see. Next on the docket, guess what? Sarah Boone, big shock, wants a new trial. Now, obviously, Sarah Boone is awaiting sentencing for her murder conviction, and her attorney is trying to get a new trial by arguing that the judge erred in his rulings and that there was prosecutorial misconduct. Now, a jury convicted Ms. Boone of second-degree murder for the death of her boyfriend, Jorge Torres, who was found zipped up in a suitcase in the couple's apartment after a night of drinking. Now, Ms. Boone testified at her trial that she had acted in self-defense and that she suffers from the battered spouse syndrome, while prosecutors emphasized that she left the victim to suffocate after additionally beating the suitcase with a baseball bat. Now, at trial, Ms. Boone was represented by James Owen. Now, while Torres died back in February of 2020, Boone's case didn't go to trial for 4 years, in part due to delays caused by a constantly changing defense team by Ms. Boone. 8 attorneys represented Ms. Boone before Judge Michael Kranick ruled that she had forfeited her right to an attorney and she was going to represent herself. Now, in the motion for a new trial, Ms. Boone's attorney, Mr. Owens, argued that the rulings violated Ms. Boone's Sixth Amendment right to representations. Owens also said that Ms. Boone's behavior did not rise to the level of misconduct requiring to sustain the ruling that the judge failed to warn her that repeated misbehavior would result in her right to have to represent herself. Yeah, that's not going anywhere. Let's be clear, ladies and gentlemen. Oftentimes, you can file a motion for a new trial prior to sentencing. It's going to be denied. Okay? I honestly don't think, one, I've maybe done it twice in my 30 years of practice of law, and I can't say that I've ever seen a criminal court judge reverse themselves. District court judges don't reverse themselves. That's what appellate courts are for. They're not going to say, I made a mistake. They're going to say, I'm going to double down on my decision and we'll let the Court of Appeals decide if they did it wrong. In this particular case, Ms. Boone made a clear record that her misconduct, her inability to get along with court-appointed counsel, was that she couldn't get along with anybody, and therefore she could in fact represent herself. Ultimately, this other attorney stepped in, Mr. Owen stepped in, basically doing the case pro bono, and he knew what the deadlines were. If he didn't think that he had sufficient time in which to prepare to effectively represent her, he should not have got on the case. And then Ms. Boone would have had a much better argument that she was deprived of her right to counsel by having to go to court with no attorney. But she had one who was aware of the deadlines and frankly did a decent job. And there you go. We'll have to wait and see. Next, and I say scumbag, DA Alvin Bragg, because I believe that's what he is. Anyway, he has been held in contempt for not turning over documents in regards to a sweetheart plea deal with a doctor who's not a nice guy. The Manhattan's district attorney was held in contempt by a state court for refusing to turn over a plea deal and documents with a doctor who was later convicted of being basically a sexual predator. Now, DA Alvin Bragg's office must now comply with the subpoena to produce the documents related to a 2014 criminal case against Dr. Robert Haddon. Now, attorneys who are representing hundreds of Haddon's victims in a civil suit is also seeking the DA's communications with Haddon's longtime employer, Columbia University, in relation to Haddon's 2016 no jail plea, which Bragg's predecessor, Cyrus Vance, was responsible for. Now, Alvin Bragg, he's still a scumbag, but he is the one there in the position, so he gets to be held in contempt. Now, this deal was struck despite Haddon admitting to sexually abusing 6 female patients during his long tenure as a gynecologist at the university. And as part of the deal, the DA agreed not to prosecute him for any similar crime that happened before February 22 of 2016. Now, federal prosecutors also noted what they called a deliberate attempt to hide documents related to this deal during their own trial back in 2020, and they should be prosecuting Columbia University, not protecting them. Anyway, the DA's office could face some penalties if the deadline to produce the documents is not complied with. Now, the current case filed in 2022 includes nearly 550 clients, and it's estimated that the liability could top $1 billion due to Haddon's sexual abuse and what he says is Columbia University's attempt to cover up that bad misconduct. But I'm sure he was just a great guy, and how dare you besmirch the good character of the good doctor. Anyway, Haddon was convicted by federal prosecutors of sex trafficking in 2023 and was ultimately sentenced to 20 years in prison. Now, victims recounted that the doctor would make oral or other sexual contact with them during what were supposed to be routine medical appointments. And the attorneys for the victims say they are seeking these documents related to the district attorney's criminal case and the plea deal because it could undercut the claim that he says Columbia has made from the beginning that they had no idea that the good doctor, Mr. Haddon, was routinely sexually abusing patients. Now, the district attorney's office has argued against complying with multiple subpoenas, claiming that there are issues, technical issues, and that the documents are protected as both privileged work product as well as grand jury materials. Columbia officials have kept their head down because they got some big liability coming their way. Really what it comes down to, ladies and gentlemen, you can't condone bad conduct. If you believe there's bad conduct, you have to nip it in the bud, so to speak. And in this particular case, if Columbia University, I'm not saying they did, but if they knew, they're going to be on the hook for such conduct. Now, if they didn't know, they had no idea, they had no way of knowing. But the fact that the DA's office was involved in these plea negotiations and included the university, just turn it over. The district attorney's job is to do justice. They should just turn it over. Next on the docket, this day in legal history. On this day in 1860, November 6, 1860, Abraham Lincoln was elected as the 16th president of the United States. And obviously, his election led to the secession of the southern states and the Civil War, ultimately resulting in the abolition of slavery and the passage of the 13th, 14th, and 15th Amendments. Also on November 6, 1934, South Dakota voted to end prohibition laws 1 year after the federal repeal through the 21st Amendment. And then South Dakota's decision reflecting changing attitudes toward alcohol regulation and influenced later alcohol policies in other states as well. And also on this date, on November 6, 2018, Florida voters approve Amendment 4, restoring voting rights to most ex-felons who had completed their sentences. This amendment had significant impact on voting rights in Florida, affecting 1.4 million people, and then obviously brings out a discussion as it relates to criminal justice reform in the future. And then finally, our dumb criminal of the day. So a Florida man, coincidentally, is behind bars after brandishing a flamethrower at police in Port St. Lucie. Now, Joseph Mortensen was arrested and charged with 1 count of aggravated assault and assault with a deadly weapon on law enforcement officers, and 1 count of resisting with violence. Now, the police department said it responded to a report of an explosion with smoke in the area of Kimball Circle on Monday night, and when officers arrived, Mr. Mortensen was allegedly yelling at officers from his backyard, and he was armed with a handheld flamethrower, and he came to his front yard where the officers were parked. The police department said it ordered Mr. Mortensen to drop the flamethrower at gunpoint, and he refused. And guess what? He did what most people do, continue to walk towards the police officers while armed with a flamethrower. Anyway, guess what? The officers got close enough. They grabbed the flamethrower from Mr. Mortensen, and then he retreated to his home. Within the home, he was surrounded by police, and they told him to come out after he ultimately appeared at the front door and attempted to blind an officer with a flashlight. At that point, guess what? The officers tased him and was taken into custody without further incident, and he is being held in custody on a $5,500 bond. Mr. Mortensen, flamethrower. I love the idea. I wanted one of those ones that the Boring Company was selling years ago, just for fun. But I wouldn't point it at the police. I get you could do it in your own backyard. You can't point it at police. Mr. Mortensen, you are a dumb criminal of the day. All right, that's all we have for today, ladies and gentlemen. We'll be back in the office tomorrow, and not this very lovely conference room here at the Mesa County Courthouse in Grand Junction, Colorado. Anyway, that's all we have for today. Have a wonderful day. We'll see you tomorrow. And remember, the Constitution matters.